All right, 24 minutes before 11 o'clock. We went a little bit long at the last interview. I apologize to everybody for that, especially John Fuller, who's in the studio right now, ready to answer your legal questions. John, of course, is an attorney at the law firm of Fuller & Fuller. This show is his show. It's called Legally Yours. And the other attorney at the agency of Fuller & Fuller is John's beautiful wife, Janet, and he'll tell you what she does in just a bit. The phone number, if you'd like to talk to John, is 622-9622. That is the WOCA Climate Control Source Hotline, 622-9622. Good morning, John.
Good morning, Larry. It's good to be here. I hope you and all our listeners had a nice weekend. It was pretty weather then, and a good St. Patrick's Day for those of the people that celebrate St. Patty's. That's the two exciting things that have happened since last week that I know
That's right.
of.
That's right.
So anyway, we do enjoy this show where people who are listening may have legal issues or questions. Certainly, if it's a potential case that an individual has, it needs to be addressed in the office so we can go over the details if someone's been hurt in an automobile accident or that sort of thing. But just in general terms, it's a pleasure to be talking about the legal system because it really affects everybody's lives. Even if you're going to college and you're renting your first apartment, you're going to sign a lease, and that's a legal document.
That's right. That's
so
right.
Everything has some connection with our legal system.
You know what you can do that a lot of hosts cannot do? You can actually demonstrate your skill on the air, because what you do with the jury and in the courtroom is words. You articulate, you defend people with the command of the English language.
Well, thank you for that. Some days may be better than other days, but I have heard it said that word pictures are very important in explaining and convincing people of a certain set of facts to be interpreted in a certain way. And lawyers are advocates. Trial lawyers are advocates. Other lawyers, they also care for their clients deeply and look after their needs, but drafting a will or drafting a contract is far different than going in the courtroom when someone's liberty, money, possessions, those things are at stake. I have from time to time a lot of young people who have asked me, and I've spoken at various career days at various schools in the area, what's a good pre-law major? And my answer is to have as broad of education as you can possibly have. And then if there is one thing that I would think would be helpful to focus on, it would be English, because words are the tools. And you're in radio. You deal with the same medium. You want to enlighten your listeners. You want to entertain your listeners. You want to address areas and express verbalize thoughts, put them into words. And so you do the same thing, and you do it very well. So,
well, I appreciate that. I don't know that.
I just wish I could play the guitar like you do, Larry. That's where we diverge.
So I have a question for you. There was a news story this morning about a man who weighed 320 pounds, and the courts decided that he was too heavy to have his children. I guess there was, I don't know if the wife was there or not, but anyway, the story said the children were put up for adoption. So I don't know where the mom was in the story, but just based on what little I just told you, because that's all I really know, a man loses his children because he's obese.
Was that a Florida case?
I don't think so.
Yeah.
I can look it up real quickly, but I
hadn't heard it.
I just thought to myself, and the logic was he won't be able to run around like them. He won't be able to keep up with them because he's too obese. So adoption is final.
Well, it is very final, and Florida law in the area of extinguishing parental rights for the biological parent is one of the most formidable tasks that someone has to accomplish if you're trying to demonstrate to a court that it's in the best interest that their biological parent has his or her biological rights of parenthood to that child or those children extinguished. Now, there's so many questions that scenario raises that we don't know the answers to, so there's nothing you can say. If the mother is not in the picture and there are no other viable family members to provide care, and the children may be special needs children who have some type of physical or mental handicap that requires special needs, and if the parent, the biological parent, is more than just morbidly obese, maybe they have high blood pressure, maybe they have diabetes, maybe there have been instances where the individual didn't properly take his or her insulin and went into a diabetic coma, and they were 3 infant children in the home without supervision with the oven on, and maybe one of the children was grievously injured, and there is no way that he is physically able to care for the children. And if the children are at risk, and this is one of the criteria, that if the judge determines that the continuation of the parents' custodial rights to minor children is contrary to the best interest of those minor children, then the first role of the judiciary is to care for the children. In fact, there is a Latin phrase, in pariens patriae, which means that you stand in the place of the parent. And the court, acting in a pariens patriae manner, steps in and determines what is in the best interest of the children. And normally, in Florida, before they would terminate parental rights, they would suspend them and place the children in a foster care home if they did not have viable alternative relatives who would come forward and take the children under a court-supervised guardianship. Now, I'm not a guardianship lawyer. I'm not someone who specializes in that area, but that's generally my understanding of what Florida does. But I know from having litigated some related type cases many years ago that it is very difficult to extinguish the biological paternity.
The phone lines are open. Your phone calls are an important part of this show, so don't hesitate to call. If you would like to call, you are not interrupting us. We invite your calls. The number here is the WOCA Climate Control Source Hotline, which is 622-9622. If you have a legal issue that is worrying you and you'd like somebody's thoughts on it, especially somebody like John Fuller, who can give you the legal side of that would be interesting for all of us. We'll all learn from those kind of calls.
Well, certainly you said that very well. We have a wonderful group of listeners. I am always pleased, impressed, and gratified when people take the time to call, and the questions that we've had on this show over the almost 2 years that we've been privileged to do this show with you have truly been enlightening. They've been opportunity for me to expand my own thoughts about the legal system. You deal with it every day, right. And then you see folks who interact with it sporadically, and it's enlightening to know what's important to them and what they are dealing with. And so we are ready to answer questions. And if we have a call, let's go to the call.
Okay. Good morning. You're on the air with John.
Good morning. Always good to hear from you guys.
Thank you.
Been on a little weather, had a little surgery, but I'm up and about now.
Well, I'm sorry you had to have surgery. I hope it was a success and that you are having a very good and speedy recovery, because I always recognize your voice, and it's always a pleasure to hear from you. And Larry and I and everyone here at this station wish you the very best in your recovery.
Well, thank you very much. I served on the foster care review panel for several years, and I'm glad that Larry did mention the question about TPR in regards to our kids from parents, because it used to be pretty difficult to do that. I mean, you have quite a bit of hearings and different things. I don't know if they still have the foster care review panel in Ocala or not, but back then Judge Singbush and a few other judges, they were real good at that, and I enjoyed, volunteering to serve on that board. One of the questions that I have is relative to adjudicating teens to adult court once they've committed a crime. My question was: is there an age, a minimum age that you can have a teen bound over to adult court when they commit a crime, basically, I guess, a felony, whatever? I'll hang up and listen to your answer. Thank you very much.
Thank you, and you make a very good point that that the courts go to great lengths to avoid terminating parental custodial rights and ultimately parental rights, and when they do it, it's a last resort. They've exhausted all other options. So you make a very good point there. On the question about juvenile law, unfortunately, I am not going to be able to answer that question specifically. Doing defense of juvenile children who are juveniles who are charged in the criminal justice system under the juvenile statutes, I simply have not handled those cases in a substantial number of years, and I do not know the answer off the top of my head as to whether or not there is a specific minimum age. I feel pretty confident that there is a minimum age at which the issue of determining whether or not they can be declared an adult for criminal prosecution exists. I would suspect that there may very well be. I simply don't know, and I will have the answer for that next week. But let me tell you generally that the standards that are applied is when the older the child, the closer the child is to being an adult, and the more egregious the crime is charged. Remember, I didn't say the crime that was committed because everybody is presumed innocent. The more egregious the crime that is charged, the more serious the offense that is charged, coupled with the fact of whether or not the individual juvenile has a substantial history of prior escalating violent conduct that has not been adequately addressed, controlled, and remedied by the juvenile justice system. That is the criteria that first the state attorney looks at. Remember, the first judge and jury of any criminal case is in the state attorney's office. And those individuals take that very seriously. Mm-hmm. I know some of those young fellows over there have had a chance to deal with one of them just recently, and I had not met him before, but I was impressed. He's 2 years out of law school, and he is wise beyond his years and very conscientious and working very hard. And I think he's, number one, is a fine lawyer, is going to be a really good lawyer, and is a real credit to Brad King's staff. And I won't mention his name because I don't think he would want or need a public endorsement from me, because he's doing his job in compliance with the oath he took as a prosecutor. And that's very, very encouraging. And unfortunately, not always happens that way across the country. But in this case, I was impressed, and I commend that young man and those like him who were very conscientious. But they make the first choice. They look at the background of the person who's been arrested. What have they previously been convicted of? What type of crimes? And if you have someone who starts out at a young age with petty theft, and then it goes into burglary of a structure, and then it's burglary of a dwelling, then it's burglary of an occupied dwelling, then it's armed robbery, and you have someone who's gone from being 14 to being 16 or 17 years old, and there is increasing violence and increasing danger that has not been addressed, and someone then does something very serious, murder, of course, being right up at the top of the list, then those are the things that the prosecutor looks at, and then he applies to have the individual declared an adult for purposes of criminal prosecution, and the judge reviews that.
Yeah. An interesting story this week was the infomercial guy, Thoreau, I think is his last name. He was sentenced to 10 years in prison, and I guess he was in jail for a period of time. And bottom line was he was selling a book that said the diet that they don't want you to know about, and the information in it was wrong, and he was misleading people. So, and I think he was ordered to not try to sell it anymore because of that. So his real conviction was contempt of court because he continued to try to sell the book.
Okay. Now we're talking about a totally different set of laws. If there's different types of contempt. There's indirect. There's direct contempt of court, and that's when someone is in the judge's presence and stands up and says something very disrespectful to the judge. Mm-hmm. And that doesn't mean disrespectful to the individual, who obviously is the judge, but it's disrespectful to the judicial system and to the position of the judge and to the office, the judicial officer, the judge. And the system won't work without an appreciation of respect and law-abidingness by the people who come before it. You may not like it, but you need to respect the system and respect the individual who is in the capacity of the judge. And you cannot go into courtroom and curse and be disrespectful and disruptive in the presence of the judge without being held in contempt of court, and they can incarcerate you for that. You can also be held in indirect civil contempt if you are ordered to pay, let's say you are ordered to pay child support, and you don't make the payment intentionally, and you have the ability and capacity to make the payment, then you can be held in direct civil contempt because they're not punishing you so much as for the failure to pay child support as the failure to abide by and respect a court's order. If you have the ability to pay and you intentionally do not pay, then you are in contempt of that court's order. You've thumbed your nose, if you will, at the authority of the court. And then the indirect criminal contempt is when you do something that is intentional, that is out of the presence of the court, but is contemptuous of the court. So the court can impose a fine. It can strike your pleadings. It can incarcerate you up to 179 days in the county jail.
Well, in his story, he was trying to persuade the judge to let him go home, basically. And he said, more or less, that he was already rehabilitated with his first year or less than a year. And the judge's response to that was, no, you have ripped off the people. You have misled the people. The judge's response was very strong. And it was interesting to watch this unfold.
Yeah. And, in the indirect civil contempt, one of the factors of that is that you have the right to purge. The court can incarcerate you and then give you what is referred to as the key to the jail cell by saying, okay, you're in willful and intentional contempt of this court by failing to pay what the court has ordered you to pay, despite the fact that you have the present capacity to do so. I am incarcerating you in the county jail, but you may purge yourself of contempt and be immediately released from jail by complying with the order. In other words, if you owe $1,000 and you don't pay it, and you have the capacity to pay it, and you tell the judge, I don't care what you say, I'm not paying her $1,000 because she is a bad person and has been a bad mother and a bad wife, and even if you tell me I owe her $1,000, I'm not going to pay her the $1,000. Goes to jail. The contempt order says that he may be able to be released from jail upon complying with the condition of the purge, which is that he pay the $1,000.
So that information could be handy if we find ourselves in hot water. For example, if we don't abide by the healthcare laws and find ourselves paying a penalty or being fined and then not paying that fine. Wouldn't that, if at the end of the year, this year, we don't pay that fine if we opted out of that?
I don't know how that works, because failure to pay a fine in an administrative capacity may not be contempt of a court order. I think they would have to exhaust whatever administrative remedies that are available first, and then apply to a court order. And then if there was non-compliance with the court order, then contempt kicks in.
Have you ever represented somebody who is already incarcerated? Somebody who's had another charge, but your client is literally serving time already?
Let me think. Well, I don't think that particular scenario has occurred in my practice. I have certainly represented a large number of people, especially in the earlier stages of my career when I did a very, very active criminal defense practice, who had been arrested and charged, and the amount of their pretrial release bail was set so high that they couldn't afford to bail out or to bond out, and their family has put together the resources to retain me or any private attorney that they might choose to hire. And so your first order of business is to apply to the court for a reduction in the amount of bail for a reasonable pretrial release. Our Constitution says that we are entitled to pretrial release, and the court, in order to keep someone incarcerated before they have a trial, absolutely. You can't just be put in jail because you're charged with a crime because you're without a reasonable bail or reasonable conditions for your release, because you're presumed innocent. And and so we don't. The bail has to be reasonable, and there are a number of factors that the court must consider. The court must consider first, should a person be released without having to pay bail or post a bond. That's what you're entitled to under the Constitution, is pretrial release pending your trial, unless there is a risk that you may flee the jurisdiction of the court and become a fugitive and not appear to answer the charges for which you're charged. And the factors and evidence that the court looks at with that is, what are your ties to the community? How long have you lived here? What is your history of employment? Do you have a good job? What are the assets that you own in this community? Do you own your home? Do you own property? What are your relationships with family? Do you have family ties to this community? Then the next thing is, what is your history of flight? What is your history of prior criminal cases? Have you ever been charged before? Have you ever previously failed to appear? And then finally, are you a risk to yourself or others? If you are released on pretrial release, are you likely to cause harm to someone else or to yourself? And each one of those factors have to be determined, and you have to start with the lowest threshold that someone should be released on their own recognizance. And if the court isn't satisfied that that gives them enough assurance that the person will appear for trial, will answer the charge, will not flee the jurisdiction, will not seek to perpetrate injury on someone else or upon themselves, then they look to the least restrictive bail that is appropriate to ensure those things. It may be requiring someone to give up their passport, requiring them to have a curfew, requiring them to wear an electronic ankle bracelet that transmits their location at all times, requiring them to check in daily with a probation officer. And then on top of that, then they look to a monetary bail. So That's
So the interesting thing I wanted to point out is that's what Arizona is up against now with this. They don't offer bail to illegal immigrants who've committed certain crimes like murder or something like that. So now the federal appeals court or whatever in San Francisco is looking at that. This is this morning's news, to see if Arizona is doing something unconstitutional. So my question, if it's a constitutional guarantee, does it apply to an illegal?
Well, you have state constitutions and you have federal constitutions, and the federal supremacy clause says that the federal constitution and rules trumps the state. And in the federal cases say that illegal immigrants are not in and of themselves presumptively entitled to pretrial release. And so I think that's the issue that is being challenged.
Oh, wow. It's an interesting world we live in, and you help us understand the legal part of it a lot better than...
Well, it's, there's not, there are not always, in fact, most of the times, there's simply not clear-cut, simple answers to the questions. In law school, it's kind of a standing joke. They give you a hypothetical problem on a law exam and ask you to write the answer. And it's not a matter of do you have the right answer of yes, this happens, or no, this doesn't happen, but how you analyze what the issues are, or what the pros and cons are, or what the arguments are that would apply to both sides of that equation. And it really doesn't much matter what you conclude, because most issues, especially in cases that get tried, have debatable issues that could go either way.
Again, as I mentioned in the beginning, you have the unique ability to demonstrate your skills simply by being on the radio. John, how do we get a hold of you?
Well, we're very happy to talk with folks who may need the services of a lawyer if it's in the area of our practice of personal injury or business commercial litigation or Social Security disability or significant complex family law matters. Our office number is 352-547-4292 for our Ocala office. Our toll-free number is 855-534-2565. We do have offices in Ocala and the Villages, and if it's a matter where you or someone in your family or someone you know have a specific legal need, you've, for instance, been in an accident or someone has mistreated or taken advantage of a business relationship or contractual matter, those sorts of things, we would be happy to schedule an appointment and see if it's the kind of case that we could help you with.
Very good. And call us, by the way, if you need that number repeated, or just go to the guest list and you'll see John's phone numbers and everything you need to know actually there, but you can call us at the radio station. John Fuller, thank you so much.
Thank you. Always a pleasure, Larry, and thanks to our listeners, and I hope everyone has a safe and happy rest of the week.
Thank you. We will take a little break and be right back.
Ocala's information station, 1370 WOCA. Ocala.
ABC News Now. I'm Karen Chase. Justice Department officials blasted Toyota as shameful as they slapped the automaker with a $1.2 billion fine for covering up evidence of unintended acceleration and other safety problems instead of instituting rapid recalls. Justice officials say